5-5, the City of Ohio versus Yadi Yadav. We are here at the defendant's motion to set aside and vacate her plea.
I don't know that the defendant's affidavit alone, I think she is subject to cross-examination on this.
I would agree.
Issue.
Call your first witness.
We'd call my client, Miss Jadi Yadav. Can you tell us how old you are?
Yeah, 35.
And are you a citizen of the United States?
No.
Charges in this case?
Theft, stolen property, and fraud.
Did you speak to Mr. Mormond prior to entering your plea of guilty about any sort of immigration consequences?
No.
Did you ever ask Brad what would happen on the immigration side of things if you were to plead guilty in this case?
I do, but then he said there will be no finding of guilt in this case, so I will be fine.
Okay. So what was your understanding of what would happen to you on the immigration side of things when you entered a plea of guilty?
At that time, I was not aware of my charges, so I thought it's ILC just like a informal diversion, and he said on the final record there will be no guilty finding of guilt, so the case will be dismissed and we will later expunge the case.
Okay. Were you ever able to consult with an immigration attorney prior to entering a plea of guilty in this case?
Not before Christopher Poe, not before January 2026.
Okay, and who is Christopher Pogue?
It's my immigration attorney.
Okay. When did you hire Mr. Pogue?
In January 2026.
And what did you learn from Mr. Pogue when you hired him?
He told me it doesn't matter if there is no finding of guilt, but once you enter in the guilty plea, it will affect your immigration and you will be deportable under this offense.
At this point, the courtroom tension starts building. The defendant is now claiming she had no idea that entering a guilty plea could trigger devastating immigration consequences tied to crimes involving moral turpitude. That's a massive issue because immigration courts often treat guilty pleas very differently from criminal courts. The key question here is simple. Was she genuinely misinformed, or is this a case of regret after realizing the long-term consequences? That distinction could decide everything in this hearing.
Okay.
And these are CIMT charges, which I were not aware of.
What was the last part?
CIMT, crime involving moral turpitude, because I was not aware of the charges. So he said that if the crime is involving CIMT, crime involving moral turpitude, they affect immigration.
Had you known that?
No.
Hold on, let me ask the question. Had you known what you know now, would you have entered into a plea of guilty in this case?
No, I would go for the trial because I was not aware of the charges before.
Have you paid the restitution in the ILC case?
Yes.
How long have you been in this country?
I mean, I was in India for 2 years, then came back in 2024. But before that, I was here for one year. So totally, it's like 4 or 5 years.
Okay, and what is your status here? How are you here?
Dependent visa. It's H4 visa based on my husband's.
And when did you first learn of there were going to be consequences for your immigration as a result of your multiple cases?
In January, after we hired Christopher Poe.
And why did you hire Christopher Pogue in January?
Because my visa was revoked in July 2025 after entering ILC.
Your visa was revoked in January 2020 or July
2025
of 2025, and you didn't hire an attorney until January of 2026?
Not at all.
Is that correct?
Yes.
Prior to getting Mr. Mormon, you had Tad Brittingham, correct?
Defense attorney Tad.
And he reached out to the sheriff's office on your behalf and spoke to them, trying to alleviate your immigration consequences before you were even charged.
Yes.
Would you agree with that?
Uh-huh.
And then you hire Mr. Mormon, and there are a couple pretrials. Would you agree with that? You didn't come in one time and plead guilty.
Yes.
There were multiple pretrials. Did he ever suggest that you talk to an immigration attorney about the consequences?
Not as per my knowledge or memory. I don't think so.
You don't think so, or he did not?
He did not as.
So when you came and you stood at this podium, and Mr. Mormon wasn't your attorney that day, Miss Arway was, correct?
Lindsay, yes.
And you went over the plea form with her, correct?
Yes.
And the judge did read you an advisement about immigration consequences, correct?
Yes.
Okay. And it's your testimony today that that's the first time you heard there could be any consequences.
Exactly correct.
Did you ask for additional time to speak with your attorney? It's a yes or no question.
Because the same day I get to know about the charges, so and she just gave me 10 minutes to sign the form, and we were not able to compute that what's going on.
Ma'am, I'm asking, when you heard the judge tell you, I'm informing you because you're not a citizen of the United States, that this could carry immigration consequences, did you ask for additional time to consult with anybody about that?
No, I didn't.
Did you tell the court that you had never been advised of potential immigration consequences?
No, I didn't.
Okay. And what's your status now?
It's my visa. I-95 is valid after expiring of visa. Then I received a mail, as long as your I-95 is valid, I'm legal here as long as I don't leave the state.
Okay.
So
until when?
Until they denied my extension. I applied for extension until I get the denial letter. I'm fine. As
Okay.
my immigration attorney.
So you're continuing to check in with an immigration officer, and you're here legally as we sit here today.
Yes.
They just are likely not to renew your visa?
I mean, I don't know. It's my immigration lawyer is just saying that as of now, the status is pending. So as long as they don't give me the final denial, I'm legal here.
So you don't even know that you're going to be deported or going to be completely denied your visa extension?
No, if this case doesn't resolve, then my immigration attorney told me that it's more likely I will be deported based on these charges.
Again, again, you don't know that you will be deported, correct?
Now, after January, I know I will be deported. Since my visa is revoked, so my extension will be more likely denied, and then I will be deportable.
Now the judge is signaling serious skepticism, and this is a turning point in the hearing. He's pointing out that months passed between hearings, contradicting the idea that the plea was rushed or forced on her without time to think. That matters legally because courts look closely at whether a defendant had enough opportunity to understand the consequences before pleading guilty. Do you think a defendant truly misunderstood the process, or is a judge correctly seeing inconsistencies in her story?
No further questions.
Mr. Duncan, again, her understanding of the legal system obviously is very limited. And again, and I'm not faulting, most lay people don't have a clear understanding. Her description of what happened in this court is highly inaccurate. So I'm suggesting that her interpretation of what her other lawyer has told her, I'm going to hear from Mr. Mormon, but I think you need to bring in your immigration lawyer because she's saying likely and maybe and things like that, because just her description of what happened in my courtroom is inaccurate. So she made it sound as if it all happened at once and it was kind of forced upon her and she had no time to think. Or there were months in between. The first pretrial was March 19th. Second pretrial was April 2nd. The plea wasn't until May 21st. I'm only suggesting that based upon what she's saying right now, she's not showing an actual prejudice that you might want to bring in because it just seems she's unclear of what the consequences are going to be. It seems very speculative to me at this point. Do you have any other questions for her?
Judge, I saw.
No, I want to let your attorney talk for you, please.
I don't have any further questions for her.
Okay, ma'am, you may step down. You can go back and join your attorney. Thank you, ma'am.
And I'm happy to bring in Mr. Pogue for that, and I apologize.
But do you disagree with, you may have a seat. Thank you. Do you disagree with what I'm saying? It because right now she still seems like she's, number one, she's very unclear about what happened in my courtroom. My notes are very accurate, and it matches what says on the docket as far as the number of times that she was here before me and the length of time between these hearings. This wasn't just a few minutes. She comes into court one time and someone's sliding a piece of paper in front of her and telling her to sign it. That's inaccurate. So, Mr. Duncan, I'm now
This exchange completely shifts the momentum of the case. The court is now focusing less on immigration consequences themselves and more on whether the defense attorney actually gave incorrect legal advice. That distinction is critical because ineffective assistance claims require more than confusion or bad outcomes. The judge appears increasingly focused on the emails and timeline, which may undermine the defendant's credibility. When documentary evidence starts conflicting with testimony in court, judges usually pay very close attention to those contradictions.
Very confused. Is it your contention that because her criminal lawyer did not give her advice with regard to immigration, that is ineffective assistance of counsel? Is that your contention?
Our contention is not that.
Okay.
Our contention is that there was advice that my client took as immigration advice as it related to the ILC process, specifically pleading guilty but not having a finding of guilt.
Well, yeah, Mr. Moorman clearly and accurately explained on this witness stand the ILC process. I mean, I would agree with what he said. It's accurate. The problem I'm having is it seems that she's blaming Mr. Moorman for her guilty plea because now because there may be additional consequences, but she sought the advice of at least two immigration lawyers. Is that true?
I don't believe that is true, Your Honor.
Well, that's what the email seemed to suggest.
Could we recall, Ms. Yetta?
Again, that's the evidence I have so far. Her affidavit indicates that she didn't get legal advice until January of 2026.
That's what her testimony was as well, Your Honor. I think the additional issue is that her affidavit says that Mr. Moorman gave her no immigration advice.
As he probably shouldn't, since he's not an immigration lawyer.
Which is also what he testified, that he referred her to an immigration attorney. The emails indicate that there were numerous immigration attorneys consulted. Her affidavit says he gave her no advice, accurately explained ILC that there would not be a finding of guilt, which is accurate, not in an immigration context, but in an ILC context. And so I think her testimony is slightly different than the affidavit, is different than the emails.
Well, let's give her an opportunity to explain some of this, because I am thoroughly confused as far as what her allegation actually is, especially against Mr. Moorman, because he indicated he's not an immigration lawyer. He indicated that he did not give her immigration advice, but instead referred her to an immigration lawyer that he used, that apparently her and her husband spoke to, and then got additional advice from a second immigration attorney. And again, I'm not sure what it is you're claiming what was ineffective about Mr. Moorman's legal advice. I mean, wouldn't you expect someone who doesn't do immigration work to refer them to an immigration lawyer, which he did, and they spoke to him? Call her and see if you can straighten this out for me, please.
It says on there, we talked to another immigration attorney. That is, you're referring to an immigration attorney other than Mr. Bill Abdallah. Is that correct?
No, could be.
Did you speak to another immigration attorney other than Bill Abdallah?
No, honestly, I didn't spoke to even Bill too, because we called Bill and he said, I talked to the bread. I would not take your case and I have nothing to advise you as of now. So
Did you ever speak to Bill Abdallah yourself?
never.
Brad explained the ILC process to you, and he mentioned a plea of guilty but no finding of guilt. Did you accept that as immigration advice?
Of course, because I thought there will be no final guilt, so I would be fine. That's what happened in the Mason case too. We entered in the guilty plea knowing that it will be dismissed with the same thing.
No further questions, Your Honor.
Here comes one of the most damaging moments for the defense. The prosecution introduces emails suggesting the defendant and her husband already knew ILC could hurt her immigration status before the guilty plea was entered. That directly challenges her earlier claim that she learned about deportation risks much later. The judge is now testing consistency, credibility, and intent all at once. If the court believes she had prior warning, overturning this plea becomes dramatically harder. Would this email evidence change your opinion of the case?
I'm going to read this email and I want you to tell me if I'm reading it wrong, okay? Hi, Brad, and this is from your husband, and you're copied on it, correct?
Correct.
Hi, Brad. We talked to another immigration attorney who agreed with Bill's advice. Is that what it says?
Yes.
Okay. So you knew what Bill's advice was.
We didn't talk to the bill.
I'm asking if you knew what Bill's advice was.
No.
So how could another immigration attorney have agreed with Bill's advice if you didn't know what the advice was?
Bill's advice was that as of now we cannot take your case, so you should discuss with your defense attorney if there is any way out or something like that.
So you then talked to a second immigration attorney who, I mean, that's not really advice, but you spoke to another immigration attorney who said, yeah, we don't.
Because as long as they don't have the charges, they ask about the charges. We said it's a felony charge, so they said as of now we thought it's we have nothing to say. Ask your defense attorney to talk to us.
And did you ask Brad to talk to your immigration attorney?
We didn't hire it then. It was just a free consultation first.
Okay, and you said you knew nothing about the facts until when?
Until we hired another attorney until December. I swear on that before December, we were not aware about the evidences, and before 21st May, I didn't aware about the charges.
Okay, I'm going to turn you to page 2. Your husband discusses the case. Is that correct?
Yes.
Yes. So he talks about the Best Buy incident, so you knew where it happened. He talks about you not realizing it was your card, so you knew what happened, and that you went back to return the camera. So what didn't you know about the charges?
I mean, that these are the CIMT charges, like theft, stolen property, and...
So you knew the charges, you just didn't know they were crimes of moral turpitude.
Correct.
Okay, so in the bottom of that email, your husband asks if you could manage to get diversion because ILC may be as bad as a conviction. Who told you that?
I think my husband might talk to someone or just Google these things that I'll say is...
But not from the numerous immigration attorneys you spoke to?
No, we didn't hire any.
You're educated, correct?
Correct.
You went to law school in India? Okay. I have no further questions.
The judge's ruling makes one thing very clear. The court believes the defendant understood the potential immigration consequences before entering the plea. Even though she may regret the outcome now, the judge found the testimony inconsistent and relied heavily on the emails, prior consultations, and hearing timeline. In the end, the motion to withdraw the plea is denied, keeping the original agreement in place. If you found this case as intense as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
You may step down. Extremely confused because it does appear from the record, regardless of what her testimony is, which the court finds to be somewhat incredible, that they did in fact speak to at least 2 immigration attorneys well before the plea. In fact, he even indicates, her husband indicates, who has not been called as a witness, but he indicates that they understood that ILC may be as bad as a conviction for immigration purposes. So they understood that back in, that's March 18th of 2025, a couple months before the actual plea. She may be unhappy with the results, but it appears as though that at the time of the plea in May of 2025, that she was aware that the plea, the ILC, could have adverse effect on her immigration status. The court will issue a written decision, but the motion is going to be denied. Anything else, folks?
No, Your Honor. Thank you.
All right, that's all.